Hello, everybody. In today's global world, disputes between companies in different countries are often resolved through international arbitration. Advocate Jacob Enoch, a senior partner at FIRON & Co., is head of its international arbitration and M&A departments. He is recognized as one of Israel's leading experts in these fields, and he's now with us. Hello, Advocate Enoch. International arbitration is one of Israel's most rapidly developing legal practices. This is a relatively recent trend. Is that correct?
Well, I think that's quite true. Recently, with the coming into effect of the new international arbitration, commercial arbitration law in Israel in February, this has become even more obvious, and I think this trend is here to stay.
For whom is this legal international arbitration tool intended? And more than that, why choose international arbitration rather than a local ad hoc arbitration procedure in the home country of one of the parties?
Generally speaking, when conducting international business, usually a party would be reluctant to submit itself to the jurisdiction of a court or an arbitration institution or an arbitrator who is nationally associated with its counterparty. It's obvious that there would be some apprehension about bias. So usually an international arbitration solution within a recognized international institute is a good solution.
And I assume that international arbitration differs from domestic legal proceedings in Israel also.
Yes, quite a few differences. Obviously, the language is one, typically in English, not necessarily, but usually. And on top of that, the rules and procedures are quite different. And if that's not enough, you have quite a significant body of unwritten rules and practices, which you have to be quite familiar with in such proceedings. So I've seen, both in Israel and abroad, litigators quite sure of themselves, assuming that the litigation process that they're familiar with is more or less the same in international arbitration.
And the laws are similar between the countries.
In this context, it's not even the applicable law. It's the process. The process is quite different, and when a litigator assumes that it's more or less the same and they can just wing it somehow, usually the client ends up paying dearly for that wrong assumption.
What should people know before engaging in an international arbitration? That is, what mistakes can be avoided?
I would say that maybe the first thing to remember is to wisely choose your arbitration institute. You need to be familiar with its rules and with the fee structures that such institute applies.
You not only represent clients, but are yourself an arbitrator. Is that correct?
Yes, I've had the pleasure of serving as an arbitrator on a few occasions, including in ICC arbitrations. This gives me the benefit of both the point of view of the advocate and the point of view of the arbitrator. Also, given the fact that I've served for many years as a member on the commission of the ICC's Commission on Arbitration and ADR, I've had involvement in its processes, including the amendment of the relevant rules. So it gives me some sort of understanding of the rules and the process behind the formulation.
So based on your rich experience, I guess you would say that this is not the sort of thing you can just ask a lawyer friend.
Yes, I would definitely say that. I think the problem arises primarily from the fact that basically any qualified lawyer in any jurisdiction can technically engage in international arbitration. But given the fact that everything about the process is significantly different from what you would typically see in local litigation, from the basic procedures, the way you draft your different submissions, the way you prepare witnesses, the way you cross-examine, and given the significant body of unwritten rules and practices, I would definitely try to choose someone with the proper expertise and experience.
Advocate Jacob Enoch of FIRON & Co., thank you very much.
Thank you.